Assalamualaikum warahmatullahi wabarakatuh. My name is Hani Adrina and I will start with introductions. In Malaysia, land is acquired under the Land Acquisition Act 1916. Land acquisition power are granted by the law to the federal, state, local and public authorities. The law of compulsory land acquisition is mainly concerned with the regulation defining the procedure to be followed in obtaining land by force, as well as the awarding of compensation to the landowner who has been displaced. And this can be done only for the public purpose. The awarding of compensation based only on market evidence to arriving the adequate compensation will be achieved based on market value. The market value.
So let's move on to the next slide. I'm going to present about the overview of this case. So this case was an objection against the award of the respondent in respect of the compulsory acquisition of land slot number of 3740 and 3102 in the Bukim of Ulumua, district of Kuala Pilah, for the purpose of building a school. There is no declaration under section 4, so the true declaration under section 8 of the Land Acquisition Act, which was published in the Gazette on June 12, 1962. So, on November 7, 1962, the collector held an inquiry under section 12 of the said act and awarded the sum of $5,000 per acre or $40,000 for the total of 8 acres acquired. The courts on a reference had to determine what was the market value of the said land acquired on June 12, 1962, and it was assisted by 2 assessors. So the issue is the award of $5,000 per acre was more than adequate for the land acquired, taking into account a rather remote building potential and any several loss which might arise as a result of the acquisition to the remaining land.
So for the objection by applicants is about against the award of the correspondence, as mentioned by Sarah in previous slide. And the collector held an inquiry under section 12 of the Act on November 7, 1962, and heard that testimony of only one expert named Ins Muhammad Ali bin Maidin, a first-class licensed appraiser and valuer called by the applicants. No further expert opinion appears to have been considered based on the notes of inquiry alone, yet the applicant argue in their grounds of objection that the collector's awards was based on the report of one Mr. Fraser as a chief valuer, who was not invited as a witness and whose report was not given before the collector inquiry. So Mr. Fong Keh Chong, the treasury valuer who was invited by the collector for the current hearing, admit that the collector was actually guided by the recommendation of another treasury valuer. Thus, there has nothing wrong about the collector's action. However, there is no doubt that if Mr. Branta have been invited to appear before the collector's investigations. So, for the relevant issue, the applicant were unable to call Ins Muhammad Ali bin Maidin to testify on their behalf because them be told of the latest spelling held. Instead, they called another valuer and appraiser named Ins Muhammad Yunus bin Muhammad Khatib, who inspected the acquired land in February 1969. He had been given a copy of report of Ins Muhammad Ali bin Maidin with which he was in complete agreement.
Mr. Fong Keh Chong, assessor on behalf of Land Revenue Collector. The land acquired is agriculture title. It may be argued that value should not exceed any element of potential building land value due to the land acquired is agriculture title. The evidence of value conveyed for the determining of market value for the land acquired. The assessor of Encik Muhammad Yunus referred to the Encik Muhammad Ali reports for the lost future profit from rubber tree 7 years are at 24,675 ringgit, are different with the opinion of Mr. Keh Chong for the land to be acquired. This is because the Encik Muhammad Ali added additional value for building potential. At 41,750 ringgit on land to be acquired. The award of 5,000 per acre is a more than adequate amount by reflecting of the considerable road frontage and have slightly superior in the building potential than the land acquired. By taking into the account the price of acquired land is as a good rubber, and adding to that element for building potential, which is 4,500 ringgit per acre, with added of severance loss with 500 ringgit per acre. The total amount of award by court decision is 5,500 ringgit per acre. The decision is a lack of one assessor, the selected of assessor Mr. Foh Keh Chong.
So let's move on to the conclusion. In conclusion, land acquisition gives a fair decision to every party, whether applicant or respondent, with adequate information. Besides that, with Land Acquisition Act, government can acquire land for the public purpose to build infrastructure for the citizen and make sure Malaysia being seen as a developed country in the world. As stated in Section 3 in Land Acquisition Act 1960, there are three types of purpose for acquisition happen, and all of three, that's purpose is for public purpose. So this will make sure Malaysia being seen as developed country in the world. So that's all from us. Thank you.